Welcome to the Matchmaker Mentor Podcast with Arlene Washburn, the show where love industry professionals, coaches, and matchmakers come to learn, grow, and elevate their craft. Each episode dives deep into the art and business of matchmaking, featuring expert insights, real-world strategies, and inspiring conversations designed to help you create meaningful connections and lasting success. Whether you're a seasoned pro or just starting your journey, this is your space to be mentored, motivated, and moved to make a difference in the world of love. Now here's your host, Arlene Washburn.
Welcome back to the Matchmaker Mentor Podcast. And here's where we're going to begin. Your contract will not protect you from chargebacks. It will not protect you from a regulatory complaint. And it will not protect you if it conflicts with mandatory consumer protection laws. That may sound dramatic. It is not. Professional matchmaking is built on trust, but trust does not replace structure, and structure does not replace legal compliance. Most matchmakers obsess over building positioning, testimonials, and client experience. Very few understand what actually determines the outcome when a client demands a refund, disputes a charge, or challenges your terms. Contracts, refund mechanisms, jurisdiction, choice of law, mandatory consumer protection, privacy frameworks, documentation standards. These are not administrative details. They determine whether your agreement is enforceable. They determine whether you keep your revenue, and they determine whether your business survives a dispute. Today's episode was originally scheduled as a conversation with Peter Namias, who works very closely with the IMC board in mediation and arbitration matters. Peter sees what happens after the breakdown. He sees what happens when a contract is tested, and he sees where documentation fails. Peter is admitted to the bar in New Jersey and New York and teaches law at an American university in Madrid. His cross-jurisdictional experience makes him particularly valuable in a profession that increasingly operates across borders. Unfortunately, our recorded conversation had technical issues, and rather than postponing this topic, I'm delivering the core framework in this solo episode. Peter will return, and when he does, we will go even deeper into dispute mechanisms and enforcement realities. Let's jump in. But here's a legal disclaimer before we begin. An important clarification. I am not a lawyer. I'm not acting as your attorney, and nothing in this episode constitutes legal advice. The content shared here is educational. Its purpose is to help professional matchmakers understand risk exposure and identify the legal questions they should be asking qualified counsel in the jurisdictions where they operate and serve clients. Consumer protection laws, contract enforceability rules, privacy obligations, and dispute procedures vary by country, state, province, and by how your agreement is formed. You are responsible for obtaining independent legal advice specific to your business model, geography, and client base before implementing or modifying contracts, refund policies, or compliance procedures. Why contracts fail matchmakers? Let's jump in. Let's start with the framework. Your contract does not exist in a vacuum. It exists inside multiple layers of rules that can include consumer protection laws in your home jurisdiction, regional or state level rules where you are established, consumer protection laws tied to where the client resides and where the agreement was formed, rules that can attach based on how you market and sell, including cross-border and online selling requirements, payment processor policies and card network chargeback rules, platform policies if you operate online, data protection and privacy frameworks. Your contract can say whatever you want, but if your contract conflicts with mandatory consumer protections, those protections can override your contract terms. That is the core risk. So let's start with point number one. Jurisdiction is the foundation. And before we talk about what goes into your contract, we need to define jurisdiction. Jurisdiction refers to the legal authority of a court, regulator, or legal system to govern a particular matter. For matchmakers, jurisdictions affect which laws can apply to your client relationship, which consumer protections can attach to the transaction, where disputes can be filed or escalated, which data privacy rules govern how you handle client information. Here's the practical reality. Many matchmakers operate across multiple jurisdictions at the same time. Your risk profile often depends on three key areas: where your business is headquartered and registered, where the client resides and where the agreement was formed, where you market and target consumers. Let me make that concrete. I'll give you an example. London-based matchmaker with a U.S. client. You are headquartered in London. You operate as a UK business. Your baseline obligations can include UK consumer protections, UK GDPR, and rules tied to distance selling when a client signs remotely. Now you sign a client who lives in New York. At that point, you need to understand whether your service model triggers New York's rules for certain introduction or referral services. And this matters because regulators do not care what you call yourself. They care what you do. So instead of guessing, the correct question becomes, does your service model fit the legal definition of a regulated dating, social referral, or introduction service in that jurisdiction? In New York, some categories of the service face very specific statutory requirements. Then those requirements can include cancellation language, formatting, refund mechanisms, term limits, and in some situations, even rules what affect pricing structure. So rather than assuming your premium contract is automatically compliant, you need counsel to confirm whether your service fits the statute, whether an exemption applies, and what disclosures and consumer rights must be included. I'll give you a second example. Australian matchmaker marketing globally. You're based in Sydney, you have a website that ranks globally, and you run ads targeting professionals in multiple countries. Australia has very strong consumer protection rules under Australian consumer law and privacy obligations under the Privacy Act framework and Australian privacy principles for covered entities. Now, here is where people get sloppy. Cooling off rights in Australia can exist in specific contexts, such as unsolicited sales and certain transaction types. They do not automatically apply as a universal rule to every consumer agreement. So you cannot paste a single cancellation window into your contract and assume it works for every sale channel. The formation method matters. Online sale, phone sale, in-person, unsolicited approach. Each channel can trigger different mandatory requirements. I'll give you a third example. U.S. matchmaker serving EU clients. You're based in the United States. You also serve clients who reside in the EU or the UK. If you process personal data of EU residents, GDPR can apply regardless of where you're based. If your contract with EU consumers through distance selling channels, EU consumer rules can apply. EU and UK rules often provide a 14-day withdrawal right for distance contracts. If a client asks you to start services during that window, they may still cancel and owe a prorated amount for work performed. In some situations, the withdrawal right can be limited after full performance when you obtain proper consent and made proper disclosures. That means your contract needs to address these mechanics accurately. A generic 3-day cancellation clause might not match the client's mandatory rights. And here's the thing, you might be thinking, highest standards wins. Let me bust that myth right now. Because you will hear people say that over and over again, the highest standards wins. That slogan helps matchmakers understand risk, but law does not apply through a global scoreboard. Here is the accurate version. When you operate across jurisdictions, you cannot contract around mandatory consumer protections that can apply based on the client's location and how the agreement was formed. So your contract and policies should accommodate those mandatory rights. That is the responsible approach. Point number 2, consumer protection frameworks vary by region. Different regions regulate matchmaking and introduction services in different ways. In the US, there is state-by-state variation. Some states have statutes that specifically regulate certain dating, social referral, or introduction services. Those statutes can require minimum cancellation windows, refund formulas tied to unused services, specific disclosures and formatting requirements, in some cases, bonding, registration, or other requirements. Other states rely on general consumer protection laws, but general consumer protection rules still matter. Misleading marketing, unclear terms, unfair practices, those can trigger disputes anywhere. European Union and United Kingdom regulate distance and off-premise consumer contracts heavily. Key concepts often include a withdrawal right for distance contracts, mandatory pre-contract information disclosure, plain language, and transparency standards. Now let's talk about consumer protections that can override contract clauses. Australia consumer law prohibits misleading or deceptive conduct. Unfair contract terms can be void. Certain sale channels can trigger cooling off rules. State-based licensing can apply to certain introduction agent models. Canada combines federal and provincial rules. Marketing, privacy, contract formation, and cancellation rights can vary by province. Quebec can impose particularly strict consumer protections. Asia-Pacific jurisdictions vary widely. Some have strong consumer and privacy statutes. Some regulate advertising aggressively. You need jurisdiction mapping if you market and sell across borders. Bottom line. Point number 3, statutes can be extremely specific. I want to use New York as a teaching example, not because every listener operates there, because New York illustrates the central point. Some jurisdictions require very specific contract features for certain service models. For example, statutes can require a cancellation notice placed near the signature line, specific headings, and minimum font sizes, and that's not just New York. There are other states with similar requirements. There's required language on cancellation rights and refund mechanisms. If a statute requires specific formatting and language and your contract does not include it, you weaken your position in disputes. And in some cases, you may increase regulatory exposure. So here is the correct takeaway. Do not copy what another matchmaker uses. If I had a nickel for every time I had a matchmaker ask me for a contract they could copy, I wouldn't need to run a school. Do not assume a template works globally. Do not assume premium pricing makes you exempt. Instead, confirm whether your model triggers a regulated category in each jurisdiction you serve. Then draft the right disclosure, cancellation mechanism, and refund mechanism for that model. Point number 4, cooling off and cancellation rights, which vary by channel and jurisdiction. One of the most common errors matchmakers make is writing a contract that includes no cancellation rights, a cancellation window that does not match mandatory rights, or refund language that conflicts with consumer protections. You need 2 concepts. First, cancellation windows can be mandated by statute in some places. Second, distance selling and online contracting can trigger additional rights in the EU and UK. And in Australia, cooling off rights can exist in specific contexts, such as unsolicited sales. The correct strategy is to map where you market, where your clients reside, how the contract is formed, what statutes apply to your specific service model. Then you implement cancellation language that matches those requirements. Point number 4, refund policies must match the real service model. Here's where matchmakers get into disputes. A refund policy can sound protective, but fail under pressure because it does not match actual operations. If your policy says refunds are based on introductions delivered, but you run a search-based service model where most labor happens before introductions, you created a mismatch. That mismatch becomes a dispute magnet. A better approach is to structure refund logic around phases of service. For example, phase 1 could be onboarding and strategy. That would include intake and profile development, search parameters and strategy, operational setup. Phase 2 could mean search and recruitment, active recruiting and vetting, background checks and verification where applicable, match curation. Phase 3 is the actual introductions and support, arranged introductions, feedback loops, adjustments and ongoing support. Now, I need to say this clearly. A phase-based model cannot override mandatory consumer protections. During any statutory cancellation window, the client's mandatory rights control. So, your contract needs language that acknowledges and accommodates those rights, full stop. Point number 6, choice of law and venue do not eliminate mandatory rights. Choice of law determines which jurisdiction's laws govern the contract. Venue determines where disputes can be filed. A common mistake is assuming a choice of law clause eliminates consumer protections. It does not. Many jurisdictions restrict unfair terms that strip consumers of statutory rights or force inconvenient forums. So you need a clause that acknowledges mandatory consumer rights can still apply. A lawyer should draft this for your situation. Your goal is enforceability and fairness. Point number 7, data protection is not optional and is jurisdiction specific. A privacy policy is not decorative. In many jurisdictions, it is required, and it should be separate from your terms of service. Your terms govern the service relationship. Your privacy policy governs data collection, use, sharing, retention, and rights. If you process data of EU residents, GDPR can apply. Canada has PIPEDA and provincial privacy rules. Australia has the Privacy Act framework and Australian privacy principles for covered entities. U.S. privacy laws vary by state. Here is another critical fix. Breach notification timing is not universal. Some regimes impose tight deadlines. Your incident response plan must map to the jurisdictions that apply to your business. And one of the most common errors matchmakers commit is sharing profiles with collaborators without clear disclosure and appropriate consent. If you share data with partners, your documentation and consent process should match the applicable privacy rules. And now for a word from our sponsor.
Building a matchmaking business that is profitable, compliant, and built to last does not happen by accident. At Love Pro Mastermind Academy, we do not just teach you how to match. We teach you how to build a business that holds up under scrutiny. From intake systems and pricing strategy to contracts, compliance awareness, data protection, and client management, LPMA provides the frameworks, templates, and implementation support you need to operate with confidence. Rolling enrollment, live training, real implementation support. Learn more at lovepromastermind.com. Because professionalism is not optional and compliance awareness matters.
And we are back. Now for point number 8, marketing and advertising standards vary globally. Where you market matters. If you advertise into a jurisdiction, regulators can treat your marketing as targeting their consumers. In the U.S., the Federal Trade Commission Act prohibits deceptive practices. In the U.K., the Advertising Standards Authority enforces truth in advertising. EU rules prohibit unfair commercial practices. Australia prohibits misleading or deceptive conduct. Canada prohibits false or misleading representations. So matchmakers need to stop treating marketing as separate from compliance. Point number 9, guarantees create legal exposure. Guaranteed match. Let's pause over here because I want to explain what this means. When matchmakers say guaranteed matches, they often mean guaranteed introductions. And introductions are absolutely something you control. The risk is not the word. The risk is ambiguity. If your website implies chemistry, compatibility, or relationship success, but your contract defines a match as an introduction, you've created a disconnect. Your website, sales language, and contract must all mean the same thing. If match means facilitated introduction, say that clearly. Don't hide it in the fine print. Don't inflate it in marketing, because when disputes happen, regulators and payment processors look at everything you said, not just what's in your contract. Consistency protects you. Another term that is problematic is guaranteed soulmate, guaranteed relationship. That language does not create confidence. It creates enforceable obligations you cannot control, and it invites disputes and regulatory scrutiny. You can commit to deliverables you control. You cannot promise outcomes you do not control. A safer approach is define the service model, define deliverables, define timelines you control, define remedies for failures within your control. Now, point number 10. Alternative dispute resolution is a tool, not a shield. Many matchmakers add arbitration clauses to avoid court. That can work in some jurisdictions. It can be restricted or deemed unfair altogether in others, especially in consumer settings. So you need jurisdiction appropriate ADR language. A safe best practice in restrictive jurisdictions is to make ADR optional or post dispute. And you still need a strong compliant handling pathway, because ADR does not stop chargebacks, regulatory complaints, or platform reports. Now, look, we've covered a lot already, and we're only scratching the surface. If this episode is helping you think differently about contracts, compliance, and risk exposure, take a moment to support the channel. Hit subscribe. It doesn't cost you anything, and it helps us with this platform to grow it and to continue to bring in strong, informed guests throughout the year, including professionals who understand what happens when agreements are actually tested. Forward this episode to a colleague who may need to hear what's being shared, not as a criticism, but as a professional courtesy. This industry improves when we raise standards together. And save this episode. There is a lot here that you will want to revisit before you sit down with your attorney to review or update your agreement. Compliance is not a one-time event. It's an operational discipline. Okay, now to point 11. Payment processors and chargebacks can override your preferred outcome. Here's what matchmakers do not want to hear. In chargebacks, card network rules and processor policies often control the outcome. Common chargeback triggers include services not delivered as described, client claims of unauthorized charge, claims that marketing misrepresented the service, lack of documentation, and fraud concerns. Processors also monitor chargeback ratios. Elevated ratios can lead to reserves, monitoring programs, higher fees, or termination altogether. So what protects you is not a clause. What protects you is documentation, evidence packages, clear service timelines, written communications, proof that what you promised matches what you delivered. Point number 12, when the contract becomes a liability. A contract can hurt you when it contradicts your marketing. It includes clauses that conflict with mandatory rights. It promises services levels you do not deliver. It is so one-sided that a court views it as unfair. It does not match your current service model. It ignores privacy and data sharing realities. This is why templates fail. A contract from one jurisdiction can be a liability in another. A contract written years ago can miss key updates. Your contract should be jurisdiction appropriate, service model specific, updated regularly, aligned with actual operations, written clearly. Point number 13, required disclosures and formatting requirements. Many jurisdictions require specific disclosures in specific formats for certain service models. That can include cancellation notices placed near signature lines, mandatory headings and minimum font sizes, pre-contract information requirements, disclosure of how services work and what the consumer is buying, clear refund mechanisms, privacy disclosures, and data sharing consent. So your workflow needs a compliance step, not after a dispute, before you take payment. Point 14, accessibility and plain language reduce risk. Contracts that are unreadable, hidden, or presented under pressure increase your risk. Many consumer protection regimes look at transparency. So best practices include plain language, clear headings, reasonable font sizes, easy access before payment, and time to review, and accessibility-aware presentations for digital documents. A court, regulator, or payment processor will ask whether the average consumer could understand what they agreed to. Make that easy. And now for the Compliance Corner, sponsored by the IMC Board at imcboard.org. The topic is client screening and duty of care, what you actually owe. Let's shift away from contracts for a moment and talk about something equally important, client screening. Many matchmakers say, I'm not responsible for what happens between adults. That mindset is risky. You are not responsible for chemistry. You are not responsible for relationship success, but you do have operational responsibilities. If you accept payment to introduce individuals, you are representing that you are exercising reasonable care in how you screen, vet, and present clients. Because if something goes wrong and you have no screening protocol, no documentation, no disclosure of limitations, no escalation process, you weaken your defensibility. Screening is about having a documented, repeatable process. Professional matchmakers should be able to clearly explain what level of background screening they perform, what they verify, what they do not verify, how limitations are disclosed, how red flags are documented, when a client is declined. When something goes wrong, the question regulators, attorneys, and payment processors ask is simple. What process did you follow? If there is no written protocol, no documentation, and no defined escalation path, defensibility weakens quickly. Screening protects your clients, your reputation, and your business. Now, before we go, here are some implementation questions every matchmaker should be able to answer before signing another client. What consumer protection rules can apply based on where I'm established, where my clients reside, and how my agreements are formed? Does my contract reflect mandatory cancellation and refund rights tied to my client base and sales channels? Which privacy framework applies to my client data, and does my privacy policy match my real data handling practices? Do I include required disclosures in the proper format when my service model triggers regulated categories in a jurisdiction? What documentation system proves service delivery and supports dispute defense, including chargebacks? When did qualified counsel last review my contract and policies for the jurisdictions I actually serve? Is my contract clear, accessible, and understandable to the average consumer before they pay? If you cannot answer these, you are operating with more risk than you realized. These are exactly the questions IMC Board helps you answer during the accreditation process. IMC Board accreditation is not a badge-only program. It is a structured review of contracts, policies, data protection practices, and compliance readiness across the jurisdictions you serve. During the accreditation process, companies receive jurisdiction-aware compliance guidance tailored to where they operate and who they serve, contract and policy review to identify gaps and missing disclosures, remediation support with clear, actionable steps, ongoing education through required continuing education, access to vetted resources, including independent ADR options and compliance tools. IMC Board accreditation signals transparency and accountability. Learn more at imcboard.org because compliance is about accountability, education, and doing the work. I want to leave you with this. Your contract is not a shield. It is a framework, and it only works when it aligns with ethical operations, compliance awareness, and documented service delivery. Do not wait for a dispute to learn that your contract does not match your client's mandatory rights. Do not assume a template built for one jurisdiction works globally. Instead, operate like a professional. Map your jurisdictions, align your marketing to your delivery, document service delivery, update your agreements, because the best contract is one you never have to enforce because you delivered well, communicated clearly, and treated clients fairly. If today's episode resonated, make sure you're subscribed to the Matchmaker Mentor Podcast on YouTube and Spotify. New episodes are released weekly and are designed to support professional matchmakers who want to operate with clarity, structure, and integrity. You can also join our monthly industry brief, On the Radar, for ongoing insight into what's changing behind the scenes in professional matchmaking. Until next time, stay grounded in your standards, intentional in your systems, and committed to doing this work at a higher level. I'm Arlene Washburn, and this is the Matchmaker Mentor Podcast.